Get ready. 3, 2, start. This appeal by special leave is directed against the judgment of the High Court upholding the judgment of the trial court whereby the appellants were convicted for an offence under section 302 IPC and sentenced to imprisonment for life. Stop. Both the trial court and the High Court disbelieved the testimony of PW6, whom the prosecution had set up as one of the eyewitnesses. Stop. Both the courts, however, relied upon the testimony of PW3. Stop. The conviction of the appellant is based upon the testimony of a single eyewitness, PW3. Stop. Both the courts found PW3 to be a reliable witness and his evidence sufficient to convict the appellants. Stop. The learned counsel for the appellants submitted before us that PW3 was not a wholly reliable witness and his conduct was so unnatural that it would be unsafe to rely upon his testimony to uphold the conviction of the appellants. Stop. Learned counsel in this connection pointed out that though PW3 was an employee of the deceased, after seeing the ghastly assault on his master, he not only did not go to the police but did not even disclose what he had seen to anybody at his home or in the village or even at the place of his work till the next day, and that too only after his statement was recorded by the police during the afternoon of the next day. Stop. The learned counsel appearing for the respondent, on the other hand, argued that since PW3 has been relied upon by both the trial court and high court, this court need not in this appeal by special leave go into the correctness of the findings recorded by the courts below on the basis of appreciation of evidence. Stop. It is submitted that from the evidence of PW3 the offence against the appellants stood amply established. Stop. The entire case revolves around and rests on the testimony of PW3 only, is not in doubt. Stop. It is now well established that conviction can be based on the testimony of a single eyewitness provided the court finds from scrutiny of his evidence that he is a wholly reliable witness. Stop. Where, however, the court is of the opinion that the single eyewitness is only partly reliable, prudence requires that corroboration of his testimony in material particulars should be sought before recording conviction. Stop. It is in the light of these well settled principles that We shall examine the testimony of PW3 Stock.